I plead the fifth and the second.
I handcuff you back to the chair, but I can fix your ankle. I'm Investigator Oswald, Council Police Department. I understand you said you'd be willing to talk to me about why you're in handcuffs?
Yes, sir.
Okay. Being it is a criminal investigation, obviously you're not free to go because you have warrants for your arrest. I'm going to read your Miranda because it's very important you understand your rights. Okay? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have them present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any question if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand each of these rights I've explained to you?
Yes, sir.
Have you previously asked any other law enforcement officer to allow you to speak to an attorney about this incident?
Yes, sir.
Have these rights in mind, do you wish to talk to me now?
Yes, sir.
I'm sorry?
Say what is it?
Have these rights in mind, do you wish to talk to me now?
Yes, sir. Yes, sir.
You don't want to talk to me?
I just call him, Mom.
Okay, you can call your mom at the jail. All right. We'll get you out of here as quick as we can.
The Miranda rights, the U.S. constitutional basis for them are the Fifth Amendment and the Sixth Amendment of the U.S. Constitution. The Fifth Amendment dealing with a person's right against self-incrimination, which applies not only when they're on the witness stand in court, but in any context. Citizens, that means you, have the right not to speak to the police and say things that might incriminate themselves. And also the Sixth Amendment right to have counsel when they are under arrest. When they are suspected of a crime, the Sixth Amendment right to have protection of counsel exists in that way. So essentially, where the Miranda rights and the Miranda warnings originate from the Fifth and Sixth Amendment. Miranda warnings specifically took root in 1966 in a U.S. Supreme Court case of Miranda v. Arizona, in which the U.S. Supreme Court basically said that for the rights to be meaningful, a suspect has to be aware of them. That's why we do this, breaking down the Bill of Rights, helping you understand what each one means, talking about Miranda rights and the Constitution, 5th and 6th Amendment, rights against self-incrimination, and also the right to have protection of counsel, due process, if you want to call the 5th Amendment, talk about that, and the 6th Amendment, right to a speedy trial. All of those things are important for you to know. So let's continue about the Miranda. If you don't know your rights, and if they're not explained to you, if you have never been informed of them before, then the rights really don't have much meaning or afford you with much protection. So with the 1966 Supreme Court ruling, the court said that when police arrest a suspect for a crime, before they can interrogate that person, they had to essentially read the rights. They had to make sure that the suspect understands those rights and that the suspect has to waive them and agree to talk to the police in spite of having those rights, okay? Otherwise, if the police don't go through this process, then any incriminating statement they would obtain may be inadmissible in court. However, there has been another Supreme Court decision, so let's see if that has affected the Miranda warning under the interrogation process, and watch this video coming up now.
You have the right to remain silent, you understand that?
Yes.
Anything you say can and will be used against you in a court of law, you understand that?
Yes.
This is the first half of a phrase used by police known as a Miranda warning, a constitutional requirement established in the 1966 Supreme Court decision on Miranda v. Arizona that says an individual cannot be questioned by police without first being notified of their right to remain silent and their right to an attorney, rights guaranteed by the 5th and 6th Amendments. On June 23rd, the Supreme Court issued a decision on Vega v. Teco, dealing with protections against self-incrimination and the Miranda rights. Following the decision, someone on TikTok asked us, did SCOTUS effectively cancel the requirement to be read Miranda rights? So let's verify. Did the Supreme Court end the Miranda rights requirement? Our sources are U.S. Supreme Court rulings, Vega v. Teco, and Miranda v. Arizona, MirandaRights.org, and David Jaros, professor of law at the University of Baltimore's Center for Criminal Justice Reform. The Vega ruling does not change whether a law enforcement officer is required to read someone their Miranda rights. If a law enforcement officer does not read someone their Miranda rights, and the person arrested says something self-incriminating, it would not be allowed to be used in court. What the ruling actually does is limit citizens' ability to sue law enforcement if they fail to read the Miranda warning at the time of questioning, and then later use that evidence in court. So we can verify, no, the Supreme Court did not end the Miranda rights requirement. Law professor David Jaros says the Vega ruling did not remove a person's constitutional right under the 5th Amendment to protect themselves from self-incrimination either. So, if you're being arrested, just remember,
You absolutely still have a right to remain silent. That nothing has changed about that. And the police are still obligated to read you your rights. And if they fail to, the proper remedy for that is that that statement should not be available to be used against you.
with your Verify, I'm Ariane Till.
I want you to study. I want you to inquire. I want you to think for yourself. Do the research. This information is meant to spark your thought to want to go and find more information so that you are fully informed. No person can tell you how to perceive information, how to think about information. That is something that once you have the information, you need to process on your own. Resource for the children. I know my rights, Bill of Rights. I think it's important for us to teach our children the rules in the society that they live in and what their role is and what that means for them as citizens or members of that society. Whether we agree with them or not, they're still going to be bound by those rules. And so thanks for watching. Like, follow, share this information. Make sure that you know your rights. Pop quiz. Does this legal maxim apply? Ignorantia juris non excusat. Ignorance of the law is no excuse. If ignorance of the law is no excuse, then why did Miranda win his case and thus lead to the requirement to read the Miranda warning? Find out next.
Ignorantia juris non excusat.
Answers
Ignorance
to the quiz
of the
question
law
are below.
does not excuse is what it means. It refers to the principle that being unaware of a law does not excuse a person from violating it. Ignorantia juris non